Hello everybody. Today I would like to explain about the appeal jurisdiction as well as special leave petition in Honorable Supreme Court of India. Many people have got a doubt that special leave petition and appeal both are one and the same, but actually not. Appeal jurisdiction in Supreme Court is under Article 132 to 134. For example, 132 deals with constitutional appeal, 133 deals with civil appeal, and 134 deals with criminal appeal. What is constitutional appeal? Constitutional appeal is nothing but on a final verdict of any Honorable High Court of Indian Territory, you can approach the Honorable Supreme Court of India on a constitutional matter. And what is called as constitutional matter? Any matter that deals with fundamental rights is called as constitutional matter. When your fundamental rights are being violated, then to secure those rights, you can approach the Honorable High Court, and if the order is in favor of you, then that's fine, and if it is not in favor of you, you can approach the Honorable Supreme Court of India with Article 132 in an appeal provision. And coming to 133, this deals with civil appeal. Any kind of matter that is land dispute or any matter that is civil in nature. Then you can approach the Honorable High Court, and in case the verdict of the Honorable High Court is not in your favor and that particular verdict should be a final verdict, and on that final verdict you can approach the Honorable Supreme Court of India via Article number 133 as an appeal jurisdiction for civil matters. And coming to the criminal matters, 134, Article number 134, even for this the same rules and regulations apply. On a final verdict of Honorable High Court, you can approach the Honorable Supreme Court of India via Article number 134 of Indian Constitution. And apart from all this, there is one special provision for Honorable Supreme Court of India, as this being the apex court, that is the topmost court of Indian territory and Indian judiciary. These powers are inherent to Honorable Supreme Court of India, that is secured with Article number 136, that is special leave petition. According to this particular article, you can come on any matter, even that is pending before the lower court or subordinate court or high court, on any order issued against you. You can approach the Honorable Supreme Court via SLP, and the court has got all the rights to inquire into the matter, and if the court feels that there is a grave injustice that has happened in this matter and no proper justice given to you by the lower court or high court or subordinate court, in that circumstances the court has got all the rights and inherited powers to take over the matter and process the adjudication of that matter, even which is pending before the lower court. But this need not be a final order from the lower court or high court. Even an interim application can be challenged in Honorable Supreme Court of India, though the main suit is pending in high court or in the subordinate court. This is all about special leave petition. So I think this video have helped you to understand the differences between appeal and special leave petition, and there is no bar for any citizen of India who is facing legal litigations in the subordinate courts or in the high court, and if they feel that there is no proper justice that is happening to them in the lower court or in the high court of that particular territory, that is that particular state, they can obviously approach Honorable Supreme Court of India via Article 136 of Indian Constitution, and the petition is named as Special Leave Petition, in Honorable Supreme Court of India. But before approaching the Supreme Court, you have to have few things in your mind. That is, your plea should be genuine and there should be concrete evidence to state that there is a grave injustice that has happened to you. For example, you have applied for a bail in a criminal matter and it is proved and evident that if you are let out from the jail, you will tamper the evidences. That being the case, if the court grants bail to you in a murder case or a case which is having a serious problem or a serious concern of the society or an individual, at that particular circumstances, you can obviously approach the Honorable Supreme Court asking to cancel the bail. First, you have to approach the High Court, and if the High Court is also not responding, you can approach the Honorable Supreme Court, though the petition is pending before the subordinate court. That is, the main petition is pending before the subordinate court. Or you can also directly come through subordinate court also to Honorable Supreme Court of India, but you should be able to prove that there is grave injustice that has happened to you by the judgment given by the lower court. Hope this is clear to you. Thank you.